नमस्ते फ्रेंड, आप सभी का एक बार फिर से वेलकम। और फ्रेंड्स, बात करते हैं कि अक्सर ये होता है कि जब हम सर्विस काल में आप विभिन्न प्रकार की एक्टिविटीज़ या काम करते हैं, उसके बाद रिटायरमेंट के बाद भी कभी कभी हमें ये लगता है कि किसी कारण से कोई एक्शन हमारे ऊपर ना हो। इस तरह के रूलिंग में नो डिसिप्लिनरी प्रोसीडिंग्स कैन बी इनिशिएटेड अगेंस्ट एम्प्लॉय आफ्टर रिटायरमेंट, सुप्रीम कोर्ट। The Supreme Court on Tuesday held that no disciplinary proceedings can be initiated against a delinquent employee if he has retired from service on attaining the age of superannuation or after the extended period of service. A bench of Justice Abhay S. Oka and the Ujjwal Bhuyan further explained a departmental proceedings is not initiated merely on issuance of a so-called notice, but it is initiated only when a charge sheet is issued, because that is the date of application of mind on the allegations leveled against an employee by the competent authority. In its judgment, the court rejected a plea by State Bank of India against a judgment of the Jharkhand High Court which quashed dismissal order issued against Naveen Kumar Sinha. The High Court noted that the disciplinary proceedings was initiated after his superannuation, including the extended period of service. It was alleged the employee sanctioned loans in favor of his relatives in deviation of the banking norms. The apex court also noted the respondent employee had actually superannuated from the service in State Bank of India on December 26, 2003, on completion of 30 years of service, but his service was extended prior thereto on August 5, 2003 from December 27, 2003 to October 1, 2010. But after order October 1st, 2010, there was no further extension of service. Upholding the High Court order, the bench said disciplinary proceedings against the respondent was not initiated on August 18, 2009, when the first notice to show cause was issued, but was initiated only on March 18, 2011, when the disciplinary authority issued the charge memo to him. The SBI's counsel claimed it was the case of the employee himself before the inquiry officer, disciplinary authority, as well as before the appellate authority that he was due to superannuate on October 30, 2012. He also did not plead either before the said authorities or before the High Court that he had ceased to be in service of SBI from October 1st, 2010, and therefore the disciplinary proceedings initiated thereafter on March 18, 2011 was void ab initio. As such, it said the High Court was not justified in accepting the challenge to the order of penalty on a completely different grounds. We are afraid we cannot accept such a contention on behalf of the applicant, where the disciplinary proceedings itself is without jurisdiction, upholding the same on the specious plea that it was not challenged on the ground of lack of jurisdictions would be tantamount to giving imprimatur to a penalty illegal proceeding, the bench said. After going through the rules, the bench said subsisting disciplinary proceeding, that is, one initiated before the superannuation of the delinquent officer, may be continued post superannuation by creating a legal fiction of continuance of service of the delinquent officer for the purpose of conclusion of the disciplinary proceedings in case as per Rule 19.3 of the Service Rules. But no disciplinary proceedings can be initiated after the delinquent employee or officer retired from service on attaining the age of superannuation or after the extended period of service, the bench said. By dismissing the appeal, the court directed the SBI to release all the service dues of the employees expeditiously and not later than 6 weeks. कोर्ट ने स्टेट बैंक ऑफ इंडिया के अपील को रिजेक्ट करते हुए जजमेंट दिया। ये हाई कोर्ट ने जो जजमेंट दिया वह सही है, और अपील को डिसमिस करते हुए कोर्ट ने डायरेक्ट किया स्टेट बैंक ऑफ इंडिया को कि सर्विस ड्यूज का ऑल रिलीज करिए एम्प्लॉइज को, नॉट लेटर देन द 6 वीक्स, 6 हफ्ते के अंदर सभी ड्यूज जो रिटायरमेंट बेनिफिट के होते हैं वो एम्प्लॉइज को दिए जाए। थैंक यू फ्रेंड्स, नमस्ते।